court to request judicial intervention relating to debt collection practices. It's estimated that credit providers have illegally deducted over R1 billion from thousands of debtors. For more on this story, I'm joined by Stefan van der Merwe, Senior Attorney at the Stellenbosch University Law Clinic. Thanks for your time, Stefan. Appreciate it. So you have found that companies are adding costs to people who are already in debt. Tell us more.
Yeah, well, absolutely. Good evening. What we have found is that when there is a judgment that's entered against the debtor, that what often happens then at that point is that the creditor will appoint collection agents or attorneys to assist them in collecting that debt. And what happens in practice is that the collection costs and the legal costs, more importantly, for those collections are then not charged against the client, so the creditor, but they simply added onto the responsibility, the bill that the debtor has to pay at the end of the day. And the problem with that is that those fees are largely unregulated. They're charged and they're not taxed. So the creditor and their collection agents can add pretty much whatever cost they want, and the debtor simply has to stand in for that, to pay it.
So how have they actually managed to get away with this for so long? People who are in debt generally can't afford to pay their bills. Now they're being charged even more than they should have.
Yep. Well, the problem is, and this is the reason that we're approaching the court, that the Stellenbosch Law Clinic as well as Summit Financial Partners, that we've decided to approach the court, because the problem is that with regard to Section 103, subsection 5 of the National Credit Act, the wording is of such a nature that some creditors struggle to interpret, or they interpret it in such a way that they, according to them, the definition of collection costs, which are capped at a certain amount, doesn't include legal fees. Other collection agents or creditors feel that it doesn't include steps that's taken after judgment. So in other words, there's issues with the interpretation of legislation, and that opens up a gap for creditors or unscrupulous certain creditors then to say that we can add more costs.
Now, tell us more about the alleged companies that are doing this, Stefan, because people need to know if they've actually fallen prey to this.
Well, what's happened is that we had decided in instituting this application to involve 49 respondents. Those respondents include some of the companies that we have in our dealings with our clients in the Law Clinic and Summit in their dealings have specifically identified as places where in the past there has been issues. Some of the banks, the National Credit Regulator, the Human Rights Commission, law societies, we've joined them because we feel that they have an interest in this matter. It's not a question that everyone who are respondents to the matter hopefully will be in a position where there's animosity with regards to this. We're actually hoping that some of those institutions will help us put this matter to court in such a way as that there can be clarity afterwards. I mean, I think it's important that we say from the start that we're not out on some kind of a witch hunt. We're not trying to victimize the credit industry or to label them or anything like that. What we're saying is that we appreciate that there should be a very healthy credit industry, and we appreciate the work that's done by creditors who make this service available and actually help to empower other people, help with the transformation of the nation. But we have a problem when people in the credit industry abuse debtors and as I say, take chances with legislation that they shouldn't be doing.
And if you actually win this battle, does it mean that people can claim back all that money that they were charged?
Well, so this is one of the things that the court will have to adjudicate on, is if the court then does decide in our favor, in other words, decide that this is the way that the legislation should be interpreted, there will no doubt be a situation that there are debtors out there who have paid well in advance of what they should actually legally have paid. So they were overcharged in the collection of their debts. And then the issue is going to be whether some of those payments might have been prescribed. So you might be in a situation that you're not allowed to collect that back because of the fact that prescription could count against you. That might be one argument. We don't know how that will be interpreted yet, but definitely there will be people who will have claims to money that's been overcharged.
And tell us, what are these added costs? Because it's not high interest. These are other costs that are added on to somebody who already owes debt.
So mostly it's legal fees. And this is part of the interpretation problem that we have, is that some creditors and their collection agents are of the opinion that, again, the definition in Section 103.5 of collection costs do not include legal fees. In other words, they say that the cap can be, you can go above the cap on the basis that you're charging legal fees and not collection costs. And this is the issue we have. So to answer your question, yeah, it's mostly legal fees that's added on after judgment.
All right, thanks so much for that. Appreciate it. That was Stefan van der Merwe from the Stellenbosch University Law Clinic. Now,